Let's raise big questions to our political guests now. Is Kejriwal being taken out of the Lok Sabha campaign as his supporters allege? Can Kejriwal really function effectively from jail? Has the PMLA been weaponized to target political rivals of the government? Some of the questions that I will raise. Adil Singh Bopara is Congress spokesperson and lawyer. RP Singh is BJP spokesperson. Priyanka Kakkar is from the Aam Aadmi Party. Appreciate all of you joining us. RP Singh, you might have heard there Justice Madan Lokur saying, based on the facts of the case as they are available in the public domain, he thinks this was a case for bail, not jail. What was the necessity for arrest, particularly so many months after the original case was prosecuted?
Rajiv, good evening. You just mentioned a friend from Congress party as a lawyer. Adil Bopara is a very learned lawyer. You didn't mention Priyanka Kakkar is also a lawyer. And you were also trying to defend the Aam Aadmi Party with Justice Lokur. You were trying to plead the case with Justice Lokur as it was as a court room happening. And in a court you were trying to defend the Aam Aadmi Party.
I'm not, no, so that's unfair. I ask question. My job is to, so let's not be unfair either to Justice Lokur or to me. Let's not again make it personal. I asked you a question. I expect the dignity of a decent answer. I said, do you believe on the basis, as Justice Lokur said, this was a case for bail, not jail? How do you respond?
Rajiv, please don't push me to, let me answer what I have to say. You had your point of view. You don't, why do you take it personal? Your viewers, let viewers judge it. Let your viewers judge it. Let viewers understand that you are trying to plead a case. So you virtually built up a courtroom here and you got Justice Lokur to say what you wanted him to say and then you pleaded the case. Let's accept it. You have certain soft corner for Aam Aadmi Party and Kejriwal and other parties. You have, nothing wrong in it. One can have agenda also as an anchor also. What's wrong in it? There's nothing wrong in it. But coming to the point, sir, Justice Lokur is not above law. If he feels so good about the case, let him go and plead this in the court, not in your studio. This is not for the studio to decide. And we don't know what all the ED has pleaded or what all ED has presented to the court. And on what ground the court has given 15 days jail to judicial custody to Mr. Kejriwal. Who are we to decide on this? And you were talking about that can he tamper with the proofs? Do you remember that Rajshekhar Reddy's case where at midnight his office was broken and then all documents were, it was alleged that his files and documents were removed from his office. The Vigilance Department head, person was heading the Vigilance Department. So as a Chief Minister, he has a track record of such activities where the midnight raids are being done on the offices of the officers to remove the files or do away with the files, whatever. That is the allegation. But fact is that court has gone through everything. Court would have seen everything. Okay. And then court could have reasonable reasons to send him to jail. Otherwise, why will court send him to jail?
Okay, so you're saying let's not question, let's not prejudge what the court has said. Let's go by the court's ruling. The court is presumably Priyanka Kakkar is the Aam Aadmi Party saying even the courts of this country have been compromised. The fact is Arvind Kejriwal is getting the due process under the law that any citizen would get. He's not an exception. He's not some, he cannot be given exceptional treatment simply because he's the Chief Minister of Delhi. According to the ED, they claim he's the mastermind of the alleged Delhi liquor scam. And they will eventually establish a money trail leading right up to him based on approver statements.
Good evening to everyone, Rajdeep ji. It's been 2 years and the ED does not know whether Arvind Kejriwal ji is an accused or a witness to date. It doesn't have a name in the ECIR or FIR. To date, there's been no trial. It's been 11 years that he's behind bars already based on 2 statements, based on 4 statements rather, but 2. Those were just those were statements. The other 2 were only about the personal secretary of Manish Sisodia ji saying that he was present in a meeting where Manish Sisodia ji gave certain documents to the secretary. Arvind Kejriwal ji was present in that meeting. That is a that is the kind of statement they have implicated him on. Is that a ground enough for arrest of a sitting CM? Second, P. Sarath Reddy and Manguta Reddy and his son Raghava Reddy, both of them gave several statements to the ED at the time when the son was arrested. Today he's gotten a ticket, the father has gotten a ticket off from the TDP in Andhra Pradesh. This person turned an approver, Sarkari Gawah, in the case after much duress and pressure, which will come to light. And his statement is also to the fact that Arvind Kejriwal ji said, meet Vijay Nair, and that is it. That is not a statement enough for arresting a sitting CM. These are 3 and 4 statements. The 4th statement is of P. Sarath Reddy, who turned an approver, gave 60 crores to BJP, and then turned an approver and got his bail. See, these are the kind of statements.
So you're saying, okay,
Rajiv, this is wrong.
Let Sardar RP, Priyanka ji, let Sardar RP Singh respond, and then I'll go to Adil Singh. Yes, respond.
One
Sardar
more
RP.
point.
No,
one more point, and you can go.
Yeah, okay.
One more point.
Yeah, do it. Go ahead.
You are missing on
one more point.
Yes.
So what has happened with these new amendments in 2018 that the BJP brought into the PMLA Act, the effect of which is that the only condition that anybody can get a bail under PMLA is if the ED does not oppose their bail. Only then the twin conditions of 45 do not come into play. So this is the entire khel that the BJP
not quite. The accused has to show that there is no offence made out. That is what the bail provision is. And that's that reverses the provision. No, ma'am, it doesn't mean that if the ED opposes the bail, the court has to. No, please do not mislead the audience. Do not mislead the audience, ma'am.
I'm not.
Yeah.
Please believe me when I say you can speak to a legal expert that today under only one condition will section 45 not be attracted. It is when the ED says that they have no objection to the bail. It is only then 45 will not be attracted.
Okay, that's your view. That's your, ma'am. You made your point. Priyanka ji, you made your point.
Now
please put a fader down. That's your view. There are people like Sanjay Raut who the ED opposed their bail, but they did get bail. So it's not as simple as that. There is a twin test and it's a very difficult one. I concede that.
Yes.
Getting bail under PMLA is very difficult. Sardar RP Singh, you want to make a point. Please make it quickly.
And it is not only Sanjay Raut. There are many others who have got bail, even in spite of ED opposed it. But it is a court who takes a call.
No, sir, but it is very difficult. Sardar RP Singh, it is extremely difficult because the onus has been shifted on the person accused.
So 14 parties approach the court. And then what did the court say? That your jugglery, give me a second, please. Your jugglery of statistics doesn't allow us to make it a rule, make it a guideline. This is what was said with the court. So all the parties tried their best, but let's admit, in case of Mr. Kejriwal, Priyanka madam is skipping for one thing. What about their friend, what is his name? Give me a second.
Sir, you think about the name. In the meantime, I'm going to go to Adil Singh Boparai.
Vijay Nair. Sorry, my apologies. My apologies. No.
Yes.
No. Second. 1 sec, 30 seconds. Vijay Nair. What was the friend name? Vijay Nair, who was staying in Mr. Gehlot's bungalow. Mr. Gehlot was called for that. And now Mr. Kejriwal is saying that I have nothing to do with Mr. Vijay Nair. It is Atishi and Saurabh Bhardwaj who was dealing with Vijay Nair. So in a way he is saying that, I am not responsible for whatever Vijay Nair has committed, whatever money he has taken. There are bank accounts, details on record which says that money has transferred.
Okay.
And it's a bank account of Hugo Bank.
Mr. RP Singh, you always complain of not getting sufficient time. You must allow now Adil Singh Boparai to speak. Adil Singh Boparai, you are a lawyer, right? I want to understand from you, do you concede that it becomes difficult in a PMLA case now for Mr. Kejriwal, as it would for any citizen, based on the facts of this case, to get instant bail? And therefore, he has to be prepared in a way for a long period behind bars.
Mr. Sardesai, the PMLA operates at 2 levels. The first level is, which is in theory, a money laundering legislation, which was designed to ensure that we comply with the international obligations under the FATF. Now, the second and the more material level is in practice, where the ED is being used by the duo of the BJP to arm twist, browbeat, coerce, and induce political opponents. Now, please understand the BJP is using the agencies to arguably run the largest, and I repeat, the largest extortion racket of the world. Now, coming to the legal points here. Firstly, statements of co-accused are traditionally and conceptually a weak type of evidence. Now, to my understanding, the only evidence which they have against Mr. Kejriwal is a statement made by a co-accused in ED custody. Now, this is something which the courts have to consider. In the absence of any corroborative evidence, whether this meets the test under Section 19. Number two, which is the Vijay Madanlal judgment, which is under review. Now, even though we respect the judgment of the Supreme Court, but to our mind, there are some fundamental problems, and I will list 4 such problems. Number one, the cardinal principle under criminal law is that there is a presumption of innocence. Under the PMLA, there is a reversion or an inversion of the burden of proof. Number two, statements made before ED officers who to our mind are akin to police officers is judicially admissible. Number three, the twin conditions. Now, please understand, under 45, which at an earlier point in time was struck down by Justice Nariman, Section 45 says that the court has to come to a satisfaction that the person is not guilty. So therefore, the threshold, once charges are invoked against you under the PMLA, securing bail means that the accused will have to demonstrate that he is not guilty of the offense. So therefore, the threshold to secure bail certainly becomes more difficult. And number four, which to my mind is something which is unheard of in criminal jurisprudence across legal systems, the Vijay Madanlal judgment says that a copy of the ECIR shall not be supplied to the accused person. Now, please tell me, if I do not even know the substance of the accusation which is against me, how do I meet the charges?
Yeah, but that is true. That is true. Adil, you make very fine points, but that is true of all accused under PMLA. That does not limit itself to Kejriwal. That's the wider point that the Supreme Court of this country has not yet reviewed the judgment of July 2022.
I'm glad you put this question to me. Now, please see the timing. This case in the liquor case has been going on for the investigation has been going on for the past 2 years. Why the arrest now? Why the arrest on the eve of the elections? And what is the evidence which they have? Unless and until the ED has something more, until the ED has a money trail, which to my mind, it has none.
They are claiming they have statements of approvers, they have statements of the likes of Vijay Nair. You're saying that's not enough?
24 hours. Mr. Sardesai, you give me the ED for 24 hours. Please understand how the police functions in this country. I don't need to say more. Please see how statements are extracted under duress in police custody. The ED officers are akin to police officers. That is why I think it is time for the Supreme Court to reconsider its position under Section 50. Statements made before the ED officers should not be judicially admissible. Okay. This is a fundamental flaw which needs to be considered.
I have a couple of minutes and I want to ask each of you a central question. It appears, as I said, that Mr. Kejriwal may well spend an extended period, may not even be able to campaign in the Lok Sabha elections. Do you believe that constitutional morality, Priyanka Kakkar, demands that he step down till such time as he is out on bail at the very least?
Rajdeepji, where is the money that you have put a case of money laundering on us? Where is the money? So they will say anything through anybody and we should just step down? Why should we? Where have we failed? We gave you a profit. Delhi is the only state which is with a revenue surplus budget which gives Jan Kalyan Suvidhai to its citizens. Tell me one BJP state which is in profit. That is because they are corrupt. They pocket the money. Why should we buckle down? Because they put a false case on us after 2 years, have not been able to establish where the money is, let alone be in money laundering.
You're saying where is the money? Mr. R.P. Singh, you want to respond to what you hear? This point has been made that where is the actual money that links Mr. Kejriwal to this liquor scam? Mr. Kejriwal, the individual now.
Well, Rajiv, for this state has been, Delhi has been in profit or in advantageous state since 1993, not now because of them. I mean, this is a wrong perception they are trying to create about that they have brought probably state into profits. Secondly, as for money trail, court has categorically mentioned something like 335 crore rupees money trail, which court has, is a court observation that there is a money trail with Manish Sisodia, and court has upheld that. One. Secondly,
no, so the court, sir, I must correct you now. I must correct you. At no stage has the court, sir, the court has not said that Manish Sisodia, the individual, has got the money, or Kejriwal. That's why I mentioned individual. The court says, court has not mentioned about specific individuals having got the money. Yes, sir.
But court has said that there is a money trail. Give me a second, Rajiv, please. I mean, you said something. Let me answer that. The court categorically said there is a money trail in with Manish Sisodia. And if you want, I'll send you the complete details of the court observation. One. Secondly,
yes,
as for money trail, Rajinder Singh Solanki, one of the candidates, give me another 5 seconds. Rajinder Singh Solanki, one of the candidates in Bartoli in Gujarat, was caught red-handed with money, some 20 lakh rupees. 20 lakh rupees, and he said, I don't own this money is of this man who's there with me. He is Angadi of the Central Party of the Aam Aadmi Party, and there is a case which is going on. And there are similar evidence in Goa now where people have on record said, yes, the money was transferred through Angadis, and there are bank account details also. Probably you should go through the remand note once thoroughly, and you'll get all the details from the remand note.
Okay. Adil Singh Bopara, yes, you want to make a final observation.
Mr. Sardesai, the BJP in its arrogance is turning the law on its head. This is a very, very dangerous proposition, and the BJP should just realize that the shoe can be on the other foot also. If you use statements of co-accused made during their period of custody, and you use
stop
that,
threatening.
I'm not threatening, RP Singh ji, किथे threaten कर रहे हैं? मेरी जरूरत होनु threaten कर सकता मैं? मैंने complete करन दो kindly. If you start using statements given by co-accused,
Chief Justice ने की क्या सी?
भाजी मैंने RP Singh जी बोलन तो दो मैनू तुसी क्यों इन्ने anxious होए हुए हो?
Go ahead, finish.
No immunity can give given politicians.
If you
Sir,
start,
RP Singh, let him finish 30 seconds.
Why are you getting anxious? Please.
Court जाके case लड़ो, sir.
This is not fair.
Yeah, put his voice down. Put his voice down. I give Adil Singh Bopara has been very silent for 30 seconds. Adil, please finish.
Mr. Sardesai, if you start a legal regime where agencies start using draconian powers and use statements made by co-accused persons in police custody as the sole basis to make arrests, I think this is an anathema. I repeat, this is an anathema to personal liberty.
Okay.
And every political party must bear in mind that the shoe can be on the other foot. Let us not use law to the point that it ushers an era of anarchy.
Okay.
This is what BJP is doing.
You made the point, as have the others. I'm going to leave it to the viewers to judge, because remember, this is a sitting chief minister who finds himself tonight in judicial custody. The law is equal for all, but the law must be equally applied to all, and that includes those in government and those in opposition. Is the ED doing that role, or is it being weaponized? That's a question that you, the viewers, will have to answer soon. Thank you all very much for joining me.